The fatigue.
Yo, 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 what's good, beautiful people? Peace, love, and law to you guys. Welcome to In God We Trust Academy podcast. And today is our work session day. Got about 8 more minutes before we get started. What's up, family? Y'all good in here?
Hi, how are you?
Beautiful, beautiful. Doing great. Yeah, doing great. Got about 8 more minutes, guys. Like, share, and subscribe with us. Let us know where y'all dropping in from. Those of you with us on social media. If you want to be able to get in the class, then you need to send an email to admin@ingodwetrustacademy.org and say that you want to join work sessions. We are in season 7 right now.
I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. I bet the sun gon' shine on me. All of the pain inside, it's hard to let the shit ride. Homicide, why they take my nigga life? Seems I got some shit with my family, I'm trying to get it right. 2 daughters, 2 mother, 2 family, that's right. This the shit I live for, I keep that shit they kill for. Try to kill my spirit, yeah, my music what I heal from. Keep that weed coming, cause I ain't trying to feel nothing. That shit broke my heart when I caught my cousin stealing some. Tell me why me, when I'm really trying to build some. There's some young niggas, little bitches set me up, huh? Should've killed them niggas since then, I done triple boy. Probably 25 to life, I pull it from my hip, yeah. I've been through the rain, I've been through the storm, I've been through the pain, and it's
6 more minutes, guys. 6 more minutes. Real Estate Alabama, what's good?
I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. I bet the sun gon' shine on me. April 11, I lost my pops. 10 months later, my daughter dropped. And you can't tell me life can't transform. And you can't tell me that I ain't the one. I done took blows from friends and family. I done made money with friends and family. When you get broke, just watch it and handle it. It's time to ride. grinding, niggas ain't down for you find that fire, and then you start racking, you find that plug, and then you start stacking the niggas.
Yes, sir.
You better stay packing, ain't doing no talking, just know it's by action. Saying you
Ready to
love me,
learn?
give
I
me
know that's
expression, we
real.
don't take pleas, ain't doing no confession, that's
Oh, we're gonna see what y'all know today.
knowing I'm a king, and I got the recipe, give me the keys, you know I'm gonna run it too far.
That's the deal for today. We're gonna see what you know.
LRP and we way up in God. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on
5 more minutes.
I bet the sun gon' shine on me. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. I bet the sun gon' shine on me. It gonna shine on me.
Absolutely. Alrighty. We got about 4 more minutes, family. Before we get started, we getting everybody in here. All up in here. What's up, Ricardo?
T. It's wrong. Excuse me, your child didn't face that.
Three more minutes, family.
Yeah, but I bet she don't know that.
What happens in 3 minutes? Class begins in 3 minutes. Yeah. Got about. It's about that time. All right. We got a few announcements to make to you guys right about now. So we're going to do that, and then we're going to get ready to jump into class. Everybody ought to be in here. Those of you that's coming on, then just come on. And if you're under the sound of my voice, what you hear today is definitely meant for you. All right, we're going to start off with the MNRP raffle giveaway tickets that we still got going. $10 a ticket, guys. And it's for a chance to win a 2026 Toyota Camry, February the 21st, 2026. And it is a pop-up shop. So if you are a vendor, you are welcome. It is going to be in Huntsville, Alabama as well. For more information, info.raffle@mnrp.net. Again, info.raffle@mnrp.net. Send an email there, and you can find out more information about that as well. And also, cash prizes will be given away. Definitely going to have a great time. But if you're interested in that and want to get those tickets, then do so. All right. We also got coming up October the 25th, 2025, a class paid in full Paid in full is about where I took a $25 money order and I paid off a whole entire car note and received the title. And I went to court to make that happen. So, and I'm going to show you how to do the exact same thing. All right. There's two tiers. There's a VIP tier, and the VIP tier involves a workshop where we're going to do a workshop with those who are in the VIP to make sure that you have all of your documentations and everything lined up, and with a, I will say, more advanced and full understanding as well. All right. And having you on the road to being able to, you know, get that title in your hand as quick as possible. All right. Also, we have our Bill of Rights class. This is actually this coming September the 13th, this Saturday, 3 p.m. Central Time. It's going to be on live stream. It's also $50 donations. Man, bring your family. Bring as many people as possible. It's very important that you understand and know your rights, as I always will continue to say this, because, yes, your children are being tried as adults, and majority of you in the United States of America do not know your rights. And even if you know them, can you assert them? Those things matter. Can you apply them? Do you know when, where, and how to do those things? And I think it's more time that we inform ourselves on those matters. So we're going to go through the Bill of Rights, making sure that you know what your rights are, how to identify them, as well as according to the law, and how to exercise those things. So if you want to register for that now, you can go to InGodWeTrustAcademy.com. The last day to register is this coming Friday, September the 12th, okay? So go ahead, lock in with us. Again, InGodWeTrustAcademy.com is where you go to make that happen, all right? Now, you guys ready? I think it's time. Let's hit that record button. Let's get started with our work session. If y'all ready, I'm ready. Y'all ready in here?
Yes.
If you stay ready, you ain't got to get ready.
Stay ready. You ain't got to get ready. You know what I mean?
Ain't ready.
All righty. Everybody say they ready. Did we hit the record button yet?
I didn't see it on my screen yet.
There you go. It popped up there. All righty, family. Welcome to Work Session Season 7 of In God We Trust Academy. Man, it's been such a beautiful season thus far. It's been amazing building up on the things that we have built up on in the past couple of weeks here. And just making sure everybody is ready, which means that you know your rights, you exercise those rights, and just taking the fear away from everybody from dealing with these courts. And I think that, like I said, I've been doing this for a minute, and when it comes to procedures and things like that, dealing with the courts, most people want to run away from that. And then a lot of you guys take our classes, and then you'll say something of, oh, well, this doesn't work for me. I tried it and I didn't receive a remedy. All remedies are sought out through court. If you cannot get it privately, then you must be able to go to a public court to literally exercise your rights and interests, or any damages or harms that has been used or taken against you. And if you don't know that, then that is the problem. So be able, guys, first and foremost, to articulate exactly the remedy and everything that you are seeking, and how to apply those to receive those remedies in a court of law and equity. Do everybody understand that?
Yes.
Got it.
It's very important that you know that. Okay? You should not move without knowing exactly, which is why we have took this time in this season to do the things that we've been doing thus far. All right. So as always, we appreciate each and every last one of you for your participation, for making this possible as well. And we give thanks to the Almighty, the Creator, for this exact moment and everything that has transpired up until this moment, allowing us still the freedom of decision and to literally decide our fate ourselves just by decision makings that we make daily. Guys, it is really a beautiful thing to have a free state of mind. All right. And don't take that for granted. Okay. So Everything that you guys hear from this point forward is for educational, religious purposes only. Anybody seeking any form of legal advice, please, 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 please do seek a legal advisor. All righty. All right, all right, all right. Are y'all ready? What's up, man? Talk to me, guys. Y'all know what time it is. Do anybody got a testimony? Is anybody being a living testimony today? Don't be afraid. There's no such thing as a small testimony. Anybody, anybody, anybody? Going once? Going twice? Going 3 times. All right, then. So now, since we don't got a testimony right now, well, I got something for y'all. Y'all finna get a test today. Hope y'all ready. The question is, are you ready? Are you ready, ready for this test that I have for you guys today? And it's based upon what we have covered in work sessions. Right? Y'all ready?
Yes.
Ready as we gotta be.
We're gonna find out now. Now, listen. You better, hey, participation is great. So I advise you guys to know, raise your hand. We'll get you called and you get the answer. And just know, again, okay, participation. Participate. All right. So, to the ones, now, my wife probably gonna get mad at me for saying this, but I'm gonna say it anyway. To the ones that wins, that gets that participates and actually gets the answer right. When I call up on your name and you get it right, and I'm going by order too. So, if you get it right, then yes, there's going to be a 50% discount for an item on our website, except for any upcoming classes. Okay? That's a deal.
Got it.
Deal.
Deal. Okay, let's get into this. So the first one is going to come from, we'll say, the last one we did was trial welfare. So we'll start with trial welfare. Let's do that one first. So the first question is, what does the concept of summary judgment and pretrial tools mean in avoiding unnecessary trials? What does the concept of summary judgment and pretrial tools mean in avoiding unnecessary trials? So basically, what is the purpose of these things? The summary judgment and the pretrial tools. Let's go. What you got? Anybody got their hands up? Don't y'all be scared. Nah. Don't be scared. Y'all can hear me now, can't y'all?
Yes, I can hear you.
All right, Miss Edwards, give it a shot.
Morning. Yeah, is it to basically get the judge to rule that, just to give you your judgment that you don't need to go to a hearing, and just basically, they're in default, they don't need a hearing. You just can get your judgment.
Okay. All right, I'm listening. All right, so we're going to hold your answer. Anybody got an answer with her? So who else had their hand up? Let me see. Who else had their hands up. Tamika Todd, you want to swing at it?
Kind of like she said, you've already went through all of your administrative processes. They are held in default. So instead instead of continuing with, like you said, an unnecessary trial, you'll submit the summary judgment to bypass all of that. Let them know they were already in default, or there was a discrepancy, whether it be violations of due process, and you just cut it off before it even gets to trial to get your judgment.
All right, all right, all right. JK.
Here, same lines, but they're dispositive motions that avoid the necessity of trial. So you kill the case early, whether it's defensive or offensive.
Okay. So let's see, guys. Based on the answers that were said here, I'm going to read to you guys the answer, and this is and you guys were actually all in line in your own words. So, summary judgment and pretrial tools allow a case to be dismissed, guys, before trial if no material facts are in dispute, using tools like pleadings, discovery, motions to resolve issues early. Just pretty much everything what you guys said. So that is correct from you guys. All right. Let's see what the next one was. The next one is, how does the burden of proof differ between civil and criminal trials? How does the burden of proof differ between civil and criminal trials? And they do. They actually do. Come on. Think about it. We just went over this too, guys. Those of you that was here. Going once. All right. Go ahead. Go ahead, KB.
I have half of the answer. For criminal, it has to be beyond a reasonable doubt.
Okay.
That's all I got.
Okay. We'll take that. All right. JK, what's up?
Okay, and the other side is preponderance of the evidence.
All right, then. Let's see here. And the answer says civil cases use the preponderance of evidence standard, while criminal cases require beyond a reasonable doubt. That is dope. Correct answers. Great teamwork there, guys. Making that happen. Yeah. So I can see, let's see here. What is our next question? Let's see. What is the strategic importance of filing timely objection and using court reporters at trial? Again, what is the strategic importance of filing timely objections and using court reporters at trial? All right, JK, you got up. You want to go swing at it first?
No, I've got it, but let somebody else. I forgot to put my hand down. Sorry, but I'll come back if nobody.
Okay, Tamika Todd.
To preserve the record.
All righty. Anybody else? Who else was next? Who was under you? Who got scared and just put their hand down? I'm calling you.
No, that was me. No, that was me, Eric. But I was going to say to preserve the record. So she already said it, so I put my hand down.
Yeah, but you better speak up anyway, though. Go ahead, Ms. Richie. Go ahead.
Prevents prejudice.
Okay. Anybody else? Ms. Edwards.
Prevent default and getting your case dismissed.
Okay. Anybody else? One more. So they're saying the burden of proof is on different sides to be on the record officially, first in time. Okay, CC Burns. Let's see. Now, here we go. It is to preserve the record, great guys, for appeal, which is essential because appellate courts only review what's on record. So Great job. And here's a bonus question to that. If there's no court reporter, what should you do? Go ahead, KB.
Put it in writing?
Put it in writing. Put it in writing and file it in a case. Absolutely. It's exactly what you should do. Okay? Now, question number 4. A jury trial allows peers to decide. Let's see. Was I telling y'all the answer? Okay, no. I was about to, though. What is a jury trial preferable to a bench trial? When is a jury trial? Not what, but when is a jury trial preferable to a bench trial and why? So tell me why. When is best for both? Tamika Todd, you up.
Well, jury trial is best because we're supposed to go, we're supposed to be able to have the full, I'm sorry, my mind just went blank. I'm so sorry. It allows a jury of our peers to actually rule. A bench trial, that's literally the judge making the decision, the prosecutor being out of place. The jury trial allows the full. Sorry, my bad, Josh. I lost my train of thought.
All right. You started off. Brent Robert, what's up?
Hey, Eric, I don't think this is the answer you're looking for, but I was just going to suggest that if the controversy exceeds $21, then you can request a trial by jury, which I think is the 7th Amendment.
Right. Which is correct. You're right, though. Not wrong. You are right. Now, JK, your go.
Hey, if the issues of law before the court are clear, then you prefer a judge, parenthetically, so long as he's not biased, because he'd know what the issue is and give you a favorable ruling versus a jury that might be confused over a clear legal issue that's confirmed by the facts before it.
Okay, great answers. Okay, so a jury trial, guys, it literally allows peers to decide the facts, right? But along with juries, you deal with emotions, people, right? Then also when it comes to a bench trial places all decision making in the judge's hands, as was said. But if you know for a fact it's strictly according to statute, etc., then it is easier to use the decision making of the judge. It just depends on basically how you are set up in order to make sure that you receive the remedy that you want to receive. But you do have the ability to waive a jury trial to accept a bench trial. But however, in all criminal prosecutions, a jury trial, an impartial jury, is literally supposed to be given to you at your request. Remember, at your request. You have to make the request. Okay? Great answers, guys. All right, man. Let's see here. What are the main causes that forces cases to go to trial instead of being resolved beforehand? So what are the main causes that forces cases to go to trial, guys? Get those hands up. JK, what's up?
I'd say lack of effective pretrial motions and summary judgment as you laid out in the first one. So in other words, not doing your work ahead of time. You're forced to go to jury trial, but you really want to resolve it as soon as possible. Come to agreement with your adversary quickly.
Great answer. Anybody else? Anybody else? Okay, Tamika Todd.
If the disagreements for liability on the issues are unclear, like who's at fault, or damages aren't able to be established before trial, then it'll go to trial to dispute.
Great. All right, so here's the answer. Cases go to trial due to weak pleadings, incomplete discovery, or failure to use motions like summary judgments, as was stated. Good, good. Y'all ready for that court now, boy? Y'all ready? Y'all is ready. What? All right. So now, why is it crucial to preserve the record for appeal during trial proceedings? Why is it crucial? Why is it crucial, guys, to preserve the record during trial proceedings? Jamel, what's up?
Peace, family. Yeah, that's what I was gonna say. You gotta preserve the record, even if they deny you, so you can go appeal it in the higher court.
Okay. Kenneth Brook, what's your answer?
It's good to preserve the record because the appellate court won't accept new evidence.
Oh, y'all is on fire. What y'all been doing? Y'all been studying or y'all been partying? What y'all been doing?
Studying.
Okay. So the answer is basically, without a preserved record, the right to appeal legal errors is lost, making trial outcomes permanent, guys. Preserve the record. Make sure you make the timely objections. Make sure you object. Objection. You have to, because without your objection, meaning that you are fully agreeing with the procedures and things that are carrying on, you must set the order. You must set the tone at all times. Let's make sure we do that. Now we have, how does incomplete discovery affect the outcome of a case before it reaches trial? Come on. Incomplete discoveries. What effect does it have? I'm going to make somebody else give me an answer. Come on, somebody else. Give me some answer. Tiff, what's up?
It violates the due process and makes it to where you can't have an effective trial.
Okay. Anybody else? I'm listening to y'all. All right, go ahead, Miss Ritchie.
Okay. Limits on evidence and the procedure consequences.
Okay. CC Burns says you can't get positive results without all facts present. That is absolutely true too. So this is the answer for you guys. This is why you must truly complete discovery. It means key facts that you're going to need to be proven for you, right? May be missing, requiring trial to resolve issues that could have been proven earlier. Now, incomplete discovery doesn't mean that you didn't ask for certain things to be given to you. Because you can do a motion or production for things to be produced for you and they never were. Then you compelled to do those things. And then after you're compelled, then you say you can do an admission. If they can't produce it, then you can do a motion of admission. That goes into the discovery. So that covers your tracks, right? Or also remember, if they try to move towards trial or anything like that, then you also have other things that we're going to go see on down. I was about to get them ahead of myself and start telling y'all answers on the next couple questions in the phases or something, but I'm going to wait. You're going to see. All right, so now we are at the part where what is the role of pleadings and proper complaints, okay, in avoiding a trial? What is the role of the pleadings and the proper complaints in the actual trial? Or in avoiding a trial, excuse me. One more time. I'm reading one more time. What is the role of pleadings and proper complaints in avoiding a trial? Go ahead, JK.
They serve to focus the issue. So to limit the trier of fact on what they're focusing on, basically puts what you're trying to say front and center and gets rid of all the extra stuff that's not relevant.
All right. Anybody else? CC said it's the way to present evidence without appearance. Okay, so pleadings set the factual and legal framework of a case, and if they are insufficient, the court cannot grant relief without trial. Okay, so that means that if everything is really set forth in hard facts and evidence, then to where you got everything layered to the T according to the law, etc. And there's no way for them to be able to dispute whether, fraudulent activity, whatever the case may be, they will settle out of court if you have a great complaint in pleadings. But if you don't, then it's going to have to go to trial in order for certain other evidence and things like that to be brought out. And that's the way it's going to need to be done, right? It can be decided by the jury. All right. So the next question is, what does it mean when the judge controls law and jury controls facts? All right. And this would be in a jury trial. So if you didn't know. So what does it mean when the judge controls law and the jury controls facts? Come on, guys. Don't be scared. Don't be scared. So say it again. What does it mean when the judge controls law and the jury controls facts? If y'all want to pass, say pass. Sovereign One Maxwell, what's up?
Is that what you were saying last week, where the judge controls what can be heard and what can't be heard, and that the jury controls the facts that it can absorb into the case of what can be, considered as part of the case and what can't be?
Okay. Since you're the only one that answered, I'll give you and then show you if you're in line with that. Richie, you want to take a chance at it too?
The judge, he does what is the law. And like he said, the jury, they do the fact finding.
Okay. So the answer is the judge determines law while the jury determines facts. Each plays a distinct role in verdict and formation. So that means that the judge is going to relate the law to the jury and how it should be, how the facts or evidence presented should be used in relation to the law. It's the jury job to determine whether something is, true or false. And they do that by the verdict, right? So there you go. That's how that works. Great answers, though. Great answers. What are the differences in burden of proof between preponderance and beyond reasonable doubt? What is the difference, guys? What is the difference in burden of proof between preponderance and beyond reasonable doubt? Brent Robert.
Well, I was just going to say, certainly in a criminal case, any kind of conviction would have to be, there would have to be reasonable doubt, where as opposed to preponderance of evidence would just be like a general consensus, as opposed to, yeah.
Okay, good answer. Anybody else? Anybody else? Go ahead.
I was just gonna say one was civil and one was criminal.
Yeah, that's a fact. But here's the answers for you guys. Preponderance literally means more than likely, more likely than. Okay. So then you have, whereas beyond reasonable doubt requires certainty. They have to be certain. You see what I'm saying? It can't, if any doubt is created, it's over. Where preponderance can meaning that over 50% of it is likely. You understand? You understand what I'm saying now?
Yeah, I do.
Yes, more likely than not versus 95% certain. That's absolutely right. Absolutely. So that is really what it is. So when you start looking at, that's why civil cases is, it's preponderance for that particular reason. All right. So now that was from the trial warfare class. Y'all guys did great on that one. Now we're going to move to this class, restitution of commercial debt. So what does the dual nature of criminal prosecution reveal about sovereign versus financial processes, guys? What does it prove here, guys? The question is again, what does the dual nature, first, what is the dual nature of criminal prosecution? So let's answer that first. What is the dual nature of criminal prosecution first? Come on, it's 38 people in here. Y'all is not just quiet. Then we got, they answering on the website though. Y'all answering on social media. What's up, Ricardo? He left. What's up, Mr. Brooks?
Does both hold monetary value? Is a value to both? If I'm saying it correctly.
Okay, that's your answer. Public and private. Okay. Anybody else? The dual.
I got that public and private. That's what I was about to say. My bad.
Well, the dual nature is first and foremost is basically, you got the criminal nature of it, then you got the civil nature of it, and the civil nature comes in restitution. Then you got the criminal nature of it, which comes through the law. So you have two tracks. You got the sovereign, which is punishment, which is according to law, and then you got the financial, which is restitution, fines, etc. And each are governed by different laws. Just so you know. So there are two, right? So now, next questions. How are restitution orders enforced like civil debts under federal law? How are restitution orders enforced like civil debts under federal law? So basically, how are restitution orders enforced like civil debts? Anybody? Y'all know. Y'all just scared. Scared to talk. Scared you're going to get it wrong. Go ahead, Empress.
Injured party.
Okay. Anybody else? All right. Restitution orders, guys, are enforced like civil judgments using liens, levies, and garnishments. That's the answer. Restitution orders are enforced like civil judgments under using liens, levies, and garnishments under 18 U.S.C. 3613. Okay? So you have to understand restitution is considered as commercial debts. Right? All right. So now, what is the role of the U.S. Treasury in handling court registry funds? What is the role of the U.S. Treasury and handling court registry funds. Mm-hmm. Go ahead, Mr. Robert.
Well, I was going to say that through the court registry investment system, all bonding and everything is processed through the U.S. Treasury. And then ultimately you have the securitization of the court case and everything else. So that's kind of vague. I don't know if that's what you were looking for, but.
Yes, well, they are deposited with the U.S. Treasury under 28 U.S.C. subsections 2041 through 2042, and they require court orders to access. So everything that you said is absolutely correct along with that. But that's what they are for. All right. Now, let's get to this next one. Y'all, only a few of y'all was in class that day, huh? How do victims enforce restitution judgments under 18 U.S.C. 3664? How? How do they do it? What does that do for them? Y'all can look it up. Y'all got cell phones, man. You know, y'all can do a little cheating or something instead of being quiet. Under 18 U.S.C. 3664, guys. Go ahead, Ricardo.
I looked it up. I ain't gonna lie. It said enforcement is automatic. Collection tools is wage garnishments, liens against property, and seizures of bank accounts and tax refunds.
Exactly. It's to request abstract of judgment to secure liens against the defendant's property, such as bank accounts, anything of that nature. All right. Thank you. Thank you. Thank you. All righty. Why does the court operate under financial statutes when handling restitution? Why? Simple answer, guys. Think of the Clearfield Doctrine. Go ahead, Tamika Todd.
Commercial.
Go ahead, finish it up.
It's commercial in nature, so since they're dealing with restitution, financial matters. So, I don't know. It's commercial in nature, so they just deal with it how they usually do with commercial papers, ordering the payment, things like that.
Okay. And you're pretty much right. It's basically when handling money, courts must follow financial rules, which means they must follow the rules of commerce or any contracts, right? Any contractual commercial natures, they have to follow the rule, not just sovereign criminal authority. Okay. Now, what does the Clearfield Trust Doctrine mean for how government acts in commerce? I pretty much just told you that answer, but you guys can say it. Go ahead, Mr. Robert.
Well, if they're effectively acting as a corporation, then they're held to the same standards as a corporation pursuant to commercial law, basically.
That is correct. Okay, so how can a trustee lawfully demand bond audits in a criminal case? How? Go ahead.
Through discovery, interrogatories, and all of the such, the tools we use.
Yeah, you can do it that way, but you can also do what?
A FOIA request.
You can do everything from the back on the private side of with the trust, because the trust has interest. So you can give that by knowing to do what? What is it called? Notice of what? Secured interest. Notice of secured interest. Okay. Now the next one is, let's see, I did that one. Yeah, well, what does it mean when the government must follow commercial standards of accounting? And you should know that. Go ahead, JK.
Is that the gap standards? Is that what you're looking for?
Pretty
GAAP? Yeah.
Yep, they have to show transparent proof and accounting standards according to the GAAP standards. Absolutely. Absolutely. All right, now we're in the writ warfare class now. What is the difference between mandamus and prohibition as a extraordinary writ? Let's go. What is the difference between the writ of mandamus and the writ of prohibition? Let's see. Go ahead, KB. Let me see what you got.
The writ of prohibition stops the court from violating your rights, and the mandamus direct a public authority to do its duty.
Correct. Great answer. Alrighty, so let's see. When can a trustee file a writ of prohibition to stop a court from exceeding jurisdiction? When can the trustee? Ricardo, you're getting put on the spot.
When all other remedies are exhausted and the higher court, that use the higher court, right, to use them to stop the lower court.
Okay, that's a good answer. Good answer. Mr. Brooks, what's up?
Is it after motioning to intervene as a third party?
That has to be done first. Good answer. Anybody else? Pretty great answers, guys, but it definitely has to be dealing with trust property. And that means that in order for it to be dealing with trust property, that would give the trustee the right to step in, to do a motion to intervene, and or a writ of prohibition to stop the lower court from proceeding without jurisdiction over certain trust property. So, correct. All right. Let's see. Why must a writ be supported by existing jurisdiction rather than create new jurisdiction? Why? Because all writs should do something. If it's a writ to a higher court, it should not create a new jurisdiction. It should only what? Go ahead, JK.
Sorry, I forgot my hand down, but I can answer. I'll give you an answer. It's because the basis of the writ has to stem from an existing case. In other words, that original case gave the jurisdiction. You're just extending some violation of that jurisdiction to a higher court. Either they're exceeding their jurisdiction or not performing a ministerial act or something.
Right. So, and what you said is pretty much right, which is a writ must aid existing jurisdiction. Okay. Not create it from scratch. So, great answer. All right. What are the minimum legal elements for filing a valid writ of mandamus? What are the minimum legal elements? Okay. See if you guys can get that one. Meaning, what does it take to file this writ? What you got for me? Come on, abuse of power and or discretion. Good answer. Coming from the chat. Ooh, don't make me call on somebody. I'm finna call on somebody then. Let's see. Let's go down the line. Who ain't answered? You don't answer, you're getting kicked out of class. Let's see here. Who we gonna put on the spot today? Who name I usually see? Nicole Phillip. What's up, Nicole?
Listen, I knew you was gonna call me. I'm like, please don't call me because I did not hear the question. I said, oh my God, no, please. If you would, please repeat the question.
Yes, I will repeat the question. Basically, what are the elements for filing a valid writ of mandamus? So think about a mandamus, what it does, and what do you have to have in order to actually file it?
I guess the first thing is a preserved record.
Okay, keep going.
A violation of rights.
Okay.
Okay. And objection to those rights being violated.
Okay. That's your final answer?
Yes.
All righty. Now I want you to pick one person out of the group to come and answer behind you as well.
Okay.
Call them out.
Okay. Kenneth Brooks.
No, not him. He already answered. Call somebody else.
Oh, all right.
He didn't answer.
Let me hit this 29 more people. Okay. Jamila Ritchie.
Yeah.
I knew you was gonna do that.
She been answering too, so pick somebody else.
Oh God. Okay. Here we go. Monique Stokes.
Oh, she called you out, Monique. Oh, she called Monique out. Monique, what's happening?
Really?
Yeah.
No, no,
She
no.
called you out, family. It is on you today. We just need a few words of encouragement about what it takes to file a mandamus. Just give us a few words.
Will we need a motion?
Okay. What else you got for me?
We need some type of evidence, right?
Okay.
I don't know. That's it. That's all I got.
Now I want you to pick one person. Pick one person out the group. This is the last person.
Okay, let me hit this button, see what's going on.
Who you got? Pick them out.
Let's go with Summer.
Summertime. Showtime, Summer. I think Summer busy. You busy, Summer? Yeah, she probably acting like she busy in the background. She ain't busy, but she acting like it. Who else we gonna call then? I tell you what.
Okay, let's do Let's do L. Has L answered the question?
Yeah. Go ahead, L. Morgan. Let's go. Go ahead, L. You got your hand up. Hit that mic and give us answers.
Okay, I got you. So the question was requirements of a writ of mandamus, right?
Pretty much, yep.
I'm gonna try. They have to have clear legal right, public duty, ministerial duty, and no adequate alternate remedy.
Nailed it. Nailed it. That is exactly right. Clear duty, clear right, no other remedy, and proof of demand and refusal, guys. It's what it takes for the writ of mandamus. All righty. So you're going to get to pick the next person for the next question, right? So just hold on here.
All right.
Let's see. What is the purpose of quo warranto in challenging unlawful office holders? Again, what is the purpose of quo warranto in challenging unlawful office holders? Pick us out. Pick us out, somebody.
All right. Carlene.
You want Carlene Elwood? She answered one too. Pick somebody.
Oh, she answered.
Yeah, pick somebody.
All right. What about KV?
She answered too. She been talking to. Pick somebody
else. Empress Majestic.
Yeah, we'll take her. She answered one time, but that's good. Let's go.
Okay. All right.
Let's go.
Okay, give me the question one more time. Give me the question.
What
so I can
is
make
the
sure I'm answering right.
What is the purpose of quo warranto in challenging unlawful office holders? Great answer, A-Dub. Go ahead.
For them to exercise a specific power or to challenge a person's legal specific power.
Okay.
That's the first just came to my mind. So that's all I got.
Ain't nothing wrong with what you're saying. Pick you somebody that come behind you and answer with you too.
Okay, pick me somebody. Let's go with Jamel.
Jamel, what's up? You on the spot?
Yeah, this is about the quo warranto.
Yeah.
Yeah, the purpose of the quo warranto is, to challenge someone's legal right to hold a public office.
Okay. Final answer?
Yes, sir. Yes, indeed.
All righty. Quo warranto asked by what authority and is used to challenge unlawful office holders or public officials, right? How is habeas corpus used to protect the living? How is habeas corpus used to protect the rights of the people? How is habeas corpus used to protect the rights of the people? So with that being forward, who are you going to choose to answer this?
Me.
You choosing yourself? Go ahead. That was pretty smart.
The purpose of the purpose of the habeas corpus is to challenge the court's legal rights with a judge's unlawful conviction, to bring someone back to court. Habeas corpus is a Latin word for just bringing the body forth. So it's basically challenging the court's conviction, to overturn the conviction, to bring someone back to court, to hopefully get them out of jail.
Unlawful detainment, absolutely. Correct. Okay. Now you got to pick somebody this time. What's the role of Rule 21 in the Federal Rules of Appellate Procedure for writ filings? Pick somebody.
Jennifer Shields.
Jennifer. Ms. Shields, how you doing?
Hello.
Oh, you got put on the spot, didn't you?
Yes, I did.
I know, and you was ready for that other question, but they answered it. So now you got hit with one you got to sit down and think about for a second.
Whew.
Federal
right.
Rule 21. What is its role in the appellate procedure?
It allows a defendant to request a transfer of their trial to another district.
Okay. You want to pick somebody?
Okay, hold on. Let me find. Jessica Jean Francois.
Okay, Jessica.
What was the question?
In the appellate procedure, what is the role? What is the role of Rule 21 in federal court?
It's it it's it has something to do with the party. It's to demit. It's grounds for dismissal for action on an action.
You want to pick somebody?
Okay.
Find you somebody. Help you out. Rule 21 of the appellate procedure. So
Victoria Walker.
Victoria, you here with us? Summer, we called your name earlier. Summer, you wasn't present.
Yes, I'm here.
Okay, what's up, Victoria? You want to try to answer this question for us?
Yes.
All right.
I'm gonna just take a guess. Is it to like ensure like fairness and like giving like proper notice to the judge and like other parties that could be involved?
Okay. All righty, we got one more lifeline for you guys. Ricardo, you the lifeline, brother. You gonna answer this question for us today. Help your peers, man. Ricardo. I think he left.
Ricardo is talking to somebody else.
Yes,
Miss-
he's not paying no attention.
Mrs. Parks. Mrs. Parks, right now she's tuning in with us guys coming. I think she's
All parties. The party was talking to provide a
Can you hear
copy.
us?
All parties.
She can hear. We can. Mrs. Parks, are you here?
I'm here.
Okay. She's
Hey.
tuning in with us guys from Alaska. So, will you answer this question for us?
I'm not 100% sure, but I'm thinking the way that you asked it is what is the role? I'm guessing when you ask for these writs, that means you've used all of your, you've exhausted all of your remedies
Okay.
prior to, asking for these particular writs because you have a remedy outside of those lower courts.
So, now that is your last and final answer from Alaska, right?
That's my last and final answer.
All righty. All right, guys. Appreciate you guys' answers for sure. But the federal rule of appellate procedure 21, it literally just governs the appellate writs, including mandamus and prohibition. It governs the writs. Okay? That's its role in doing it. Okay, so you got to literally be able to apply the procedure that you're looking for. So it outlines the procedure for petitioning for extraordinary writs, such as mandamus, prohibitions, things of that nature. And a petition must include the relief sought, issue facts, reason for the writ, and relevant parts of the record. The court can deny the petition, order the respondent to answer or serve the order on all necessary parties. So it governs that for you guys. Okay. Now. Ready for the next question. When should a writ of certiorari be used to challenge fraudulent or defective rulings? All righty. Ms. Parks, we want you to pick the next person.
Okay.
When
Lord, I
should
don't
you
know how to
use
do.
this writ? And let's pick somebody. Who you got in mind? You can pick anybody. It don't matter.
Um, all right, let's go with Tawanda Harris.
Uh-oh, Miss Harris, we got you. Are you present? Are you able to answer? Are you working? Are you whooping children? Okay, pick someone else.
All right. What was the question one more time?
The question is, when should a writ of certiorari be used to challenge fraudulent or defective rulings? When should it be used?
I don't know.
I
that
couldn't answer.
answer.
That's why I didn't say nothing.
So it's okay, Tawanda.
I
I
know
would
wrong
say
with it.
when
Just
the
pass.
judge.
Just say you pass and you pick the next person. So who you want to answer behind you, Miss Harris?
Take that
Let Miss Parks go.
She throwed it back to you, Miss Parks. You got the answer.
All right.
You can pass if you like or answer. I know who has the answer right now. They got their hand up.
I'm gonna say when the judge abuses their power, but I'm gonna go with L Moore. He got his
Okay.
hand up.
L Moore, what's up? She's going with your answer. Do you win, everyone?
So that should be used when you're requesting the Supreme Court to review the lower court's decision.
Okay. That's the last and final answer for you. Do you got anybody else you want to pick?
Let me see. Let's go with Sovereign One.
Sovereign One, Maxwell, what's up? Sovereign One Maxwell might be shifting gears right now. Pick somebody else.
All right. Let's go with Lori.
Lori. Present Lori? Pear Tree?
Yes, I'm present. I was like, I know they're gonna call me.
Yeah,
I
we
just
got
came in
you.
different. That's okay. I'm gonna try. It has to do with, I guess, when how can I say it? When the lower court was influenced, or I don't know if I'm saying that right. I'm not sure. I'm gonna pass it on to somebody else. I'm not sure.
All right, who you gonna pick? Last one.
Oh my gosh. Let me see. Who am I gonna pick? Let's go with Marcus Bridges.
Oh, Marcus. We got Marcus on the Marcus Bridges. What's happening? Are you present, Marcus? Going once, going twice. Alrighty, I'm gonna give you guys the answer. The answer is When you use first of all, certiorari the writ of certiorari is used for errors that has been made, or fraud or anything like that has been seriously done in the court. But you can only use it when there's no appeal available, okay? And when it's unavailable or insufficient, then you use the writ of certiorari. So when does an appeal becomes unavailable? It becomes unavailable or insufficient when time has passed by. So now you can do a writ to deal with the legal errors. Got it?
Yeah, let me ask you. So, a writ of certiorari, certiorari would be considered like that would be considered like equity, correct?
All of it's all writs are equity.
Right. Okay. All right.
Yeah. Because
Can
we're
you
wanting
spell that,
wanting
please?
something to be done based upon the legal errors that was caused in the court session in error. That's what it is.
So is that like when the judge gives you an order to pay something and you don't have the money to pay, and then they find you like a violation of the order? Is that
Well, it ain't even really
mainly like
that. I mean, that is a legal error, but the point is of this is you only do it when time has fully elapsed on an appeal or something of that nature. There's no way for you to do an appeal, and if you did an appeal, it's insufficient anyway because it's not going to look at the errors. So you got to look. Remember, if you do an appeal, then you're doing it based upon what process, facts, and finding, right? But if you're doing based on errors, then it has to be done through the certiorari. So you can't do bring certain that's dealing with legal errors only in an appeal. It'll be insufficient. You get what I'm saying?
Can you spell that word, please?
Spell what word?
The writ you're talking about right now.
CERTIORARI.
Thank you.
All right. So the next question is, what makes extraordinary writs a fiduciary tool and not a protest? And that's a very simple one. Go ahead and answer that for us. Let me see. Scroll on down. What's up, Jeannie?
I knew you were gonna call my name. What was the question again?
So basically, like, what makes extraordinary writs like a fiduciary tool, and basically not a protest? So, are you arguing and protesting with this particular tools, or are you enforcing? Is basically what I'm asking.
It's my understanding that writs are to enforce other things that you haven't been able to get addressed in like a lower court situation.
Absolutely, great answer.
Oh, thanks.
Correct. All right. How trust instruments such as UCC1, security agreements, etc., are used to support in certain writ petitions? How can they be used? And that's easy because it shows what for the trust. I'll let anybody answer that. Just say it.
Interest and
The trust has interest.
possession.
Exactly. Great answer. All right, now we're in the credit warfare class, guys. So, what legal duties does a CRA, CRA means credit reporting agency, have under FCRA subsection 1681 EB for data accuracy? What should they do? Credit reporting agencies. This is from the credit warfare class. See what y'all know. Hey, yeah, I just want y'all to know that Mike L, Commander, has been running for me from Call of Duty, but that was just an ad thrown in there. Now go ahead, guys. Tiff Doe, you want to answer the question? Go ahead.
They have to ensure maximum possible accuracy.
Okay, okay. And that is exactly what they need to do, right? Great answer. So, why must original documentation be available for an account to stay on a credit report? Tiff, you answered that. You want to swing it to someone else?
Can I give it a shot real quick? I just
Yeah,
want
for sure. Shoot your shot.
um because they have to be able to prove the right to enforce the debt or the I think what is it chain of assignment or something of the sort.
Okay. So if there is no original contract, the CRA cannot legally report the debt per the rule of evidence and the FCRA standards because they have no what? Delegation of authority, which means they haven't proved what? Maximum possible accuracy, right? Great answer. Alrighty. What does the dispute process under FCRA subsection 1681 IA how does it protect your rights? How does the dispute process under the FCR protect your rights? Pick somebody, Tiff.
Okay, let's pick somebody. Let's pick Angie, Our Healthy Life. It stops. Angie.
Angie who?
It says Angie, Our Healthy Life.
Oh, Angie, you at work? You busy? I think she might be working. She be listening in all the time. So pick somebody else.
Okay. What is SMMG Workstation 2?
We had somebody in her name that. So what's up, Workstation? SMMG Workstation 2. Are you with us? I'm gonna start sending paramedics to y'all non-respondents, to y'all IP addresses and stuff. You know we can find y'all. All right, Robert the Registered. You ready? Registered agent. You ready? You got an answer for us? We miss Robert.
No, I don't know the answer. Sorry.
All righty. Anybody else with the answer want to answer for us right now? Go ahead, Miss Edwards.
Is that to do with a reasonable investigation?
Absolutely.
Oh,
It means they have to fully go back and redo a full reinvestigation to do what? Prove maximum possible accuracy. All right. Now, let's go to the next one. What happens when a furnisher fails to conduct a proper reinvestigation under FCRA? What happens? What happens? I tell you what, ain't shit gonna happen if you don't do nothing about it. I tell you that much. Ain't nothing gonna happen if you don't do nothing about it. Right? They have to remove the debt. Paul's goes God's child. Absolutely. That is correct. Alrighty, everybody was quiet in here that time. So let's go to the next one. What does Cushman versus TransUnion say about CRA responsibility during disputes? What they say? What did the Cushman smoking that good stuff? versus TransUnion. Yeah. What did it say? Anybody? Go ahead, Mr. We ain't heard you in a minute, JK. What's up?
What, were you calling on me or were you're skipping? I'm just guessing that they have to cease all activities until the disputes resolved.
Okay. Anybody else?
Is it for failing to reinvestigate, like properly reinvestigate the account? Wasn't that what that case was about?
Pretty much. But it's a key word in there. Go ahead, Miss Edwards.
Is it something with they can't just transmit cold, that they have to do a proper investigation?
Okay. Mr. Moore, you close. All y'all are right in the vicinity. It means that it was ruled that the CRAs must independently verify the data, not just accept the furnisher's word. So that means that the furnisher just can't say, yeah, we got a contract. No, they have to show and send proof and show proof of the original. I keep telling y'all to make sure you ask for that. Have they clarified? And the only way they can make sure that the maximum possible accuracy exists is to see the original. Have you went and fully investigated to be shown the original note and that they hold the original note in order for them to make these claims and credit reports that they're making? And guess what? They're not going to be able to because all of these things are pooled assets into securitization trusts. So how they gonna go look when they can't even leave out of the trust? It's irrevocable. Yes, sir. Yes, sir. Yes, sir. Okay. So how does the best evidence say what now?
What case was that?
Cushman,
TransUnion versus
Cushman.
Cushman. Okay.
All right. How does the best evidence rule apply to debt validation?
Best evidence rule is Rule 2001, the original note, original promissory note.
Okay. Anybody else? Best evidence rule. It requires the original contracts to be produced if content is disputed. Right? So you're right. All right. What is the legal consequence of failing to verify debt origin before reporting? What's the consequence, guys?
Say that again.
Basically, what is the legal consequences of the CRAs failing to verify debt origin before reporting, or even the furnisher?
Well, I know 15 USC 1692K is civil liability. That's $1,000 per violation.
Okay. Mr. Brooks, you had your hand up.
Yeah, I was about to say the same thing. You could hold them civilly liable now for damages.
Absolutely correct. Okay. So why is duplicate reporting or unverified data a violation of federal law? Come on. Anybody. Duplicate reporting or unverified data is a violation of federal law. We already proved that, but then if they keep duplicating reporting, what does that mean? And how does it happen? This happens because they do what they call batch reportings. And you know why? I keep telling y'all this. Because everything is in a pooled asset. So they take all these assets and they report based upon the batch of assets they have in the pooling. And they do it, well, based upon whatever monthly or, how many ever days they do it, but they do it. But if they keep doing it and they fail to verify their accuracy before publishing, then it goes back to what we said earlier for civil liability. So what are statutory damages under FCRA 1681N for willful violations? And y'all just pretty much said that too. Say it again.
$1,000.
$1,000.
Yes, sir. $1,000 incident plus punitive damages. Right? How does credit reporting system use batch uploads that bypass legal verification? Come on, come on, come on, come on. How does credit reporting system use batch uploads that bypass legal verification? And that goes back to independently verifying. They're not independently verifying. They're using something. Go ahead, speak. You can speak.
They're using the
They-
e-Oscar system. I'm sorry.
All right,
Go
go
ahead,
ahead,
Jamel.
Miss Parks. She'll go.
Oh no, I was gonna tell Jamil, go.
Yeah, I said they're gonna use
Automation.
I'm sorry.
Exactly. Automation. So the fact that they rely on automated uploads and do not check if data is contractually valid or backed by assignment, that means that they didn't what? Fully verified as well. It can't be independently verified to the maximum possibility if they're doing automated uploads. No way possible. All right. Now we're on estate defense tactics class, guys. We're getting close to the end. You guys doing pretty good. I know these are a lot of questions, but this is what we have talked about so far in season 7, and we got to make sure you guys on point. All right, so the Federal Rules of Civil Procedure, Rule 24A2, guys. This is what I want to know. How does the trustee intervene using the Federal Rules Civil Procedure Rule 24A2 to protect estate interests? How? Anybody? Tamika.
Motion to intervene.
Motion to intervene as a third party intervener.
Exactly. Motion to intervene allows a trustee to intervene as a right to protect the trust secured interest. And that is exactly what you're supposed to do. And, well, what is the lawful strategy to block liens, levies, or foreclosures against the trust? Go ahead.
Well, I imagine it would be an injunction, wouldn't it?
That's a good answer.
To enjoin them from attaching or leaning the secured property.
Injunction is a good answer to do. A petition for an injunction. Declaratory judgment is also a good one to say. But if you're also in dealing with a case already, then it needs to be what you call motions to quash or enjoin, as you just said. So, good answer. Good answer, good answer, good answer. What makes a motion for bond audit a powerful remedy in both civil and criminal court? Why is that a powerful tool to use, guys? Mr. Brooks.
It exposes the bonds that's governing the case at the moment.
All right, Richard.
I was gonna say it shows the commercial side of the court, how they're profiting off the case. So you could attack that angle.
Ricardo.
Yeah, I was gonna piggyback off of him what he just said. So basically, you showed them that now they owe you equity off of that.
Okay. Well, that's pretty much what it's for. It is an advantage to the trust if the trust has rights or interest in some form of property or funds that's being used. So what would they be using in these bonds that would be considered trust property? Go ahead.
The name, all caps, legal fiction.
Come on, say it better. Say it better than that.
Our intellectual property.
Oh yeah.
Say
Human capital.
intellectual property, trademarking, all of that. You know, identify the actual asset for sure.
Okay.
All right. So now, what is the role of constructive fraud and estoppel by acquiesce in defense tactics? What's the role? What does it do? Constructive fraud and estoppel. by acquiescence. So acquiesce means what?
When
To
you don't
consent.
say
The
anything.
agreement by silence.
Meaning they were silent. So since they went silent, what happens?
They waive their
Technically
right.
With their
They
rights.
agree, right, to the constructive fraud and estoppel. Now that blocks agencies from acting without authority or consent of the secured party. Now, if it's a debt collector and after you have stopped and blocked and cease and desist or told them not to communicate or whatever again, and they communicate with you, what happens?
You can sue.
Discharge.
How much? How much is it for harassment? It's like $1,000.
$1,000.
Yeah. For every damn phone call, every communication, every letter. This is why I told y'all, man, for real, man. You can make at least up to $20,000 to $30,000 off cleaning your credit reports up if you guys do it right. Because once you start sending out these letters and then they don't answer or they acquiesce to these things and then they still harass you in certain things and then you've already did these things and then the credit reporting agency just pops up and put it up there again after they haven't proven it the first time. So remember, when you do start sending stuff to these credit reports, you want to also what? Examine the full investigation for yourself. You have rights to see that. What was used for them to determine that? And if they don't show that to you, then, well, how much they owe you again for damages and punitive damages?
$1,000.
Exactly. So why must all trust claims be backed by a security agreement or UCC-1?
That's the perfection.
It is the perfection of the interest in the estate, if you choose to do that. It does not necessarily have to be a full financing statement or whatever, but at the same time, it can be because there's two considerations between the trust and the estate. The trust is going to give all of its administrative power and things of that nature for the estate. And while the estate itself is going to offer all of its property, whether tangible or intangible, as collateral in this security agreement, which makes the trust now first in line, first in right to any and all form of property. And that's what you want it to be. Okay? So again, how do you lawfully convert administrative hearings into private equity jurisdictions?
Convey it into the trust.
Hey, that's exactly what happens. When agencies become liable, when trustees convert administrative processes into private equity jurisdiction all day long. When it's in the trust, so when it deals with trust property, it's on a whole different level. It's not subject to anybody's disputes about anything that's contractually dealing with a trust, because the trust has what it calls a legal, what do we call it? You know the word I'm looking for. Has a legal title. Jesus, guys. Y'all let me stumbling over that. I was supposed to have my back. All right, so what was next? We did that one. Why should the trustee never argue identity but only enforce fiduciary standing? Go ahead.
Do you mean because if you, I guess, are not representing, if you're not coming in as a third party intervener, then the trust has to be represented by an attorney at law. Is that what you're referring to?
Pretty much that, and the fact that it's no point when you're only there for fiduciary capacity and that you're not being held for full liability as a debtor yourself. So, agreed. All righty, guys. 3 more questions here. All right. How does Rule 17A1E designate the trustee as the real party in interest? So that's through civil procedures, if you did not know. Basically, it has everything to do with what? In order for it to even make the claim, it has to have what? It's pretty kind of like a repetitive question coming from earlier.
Some sort of interest in the trust.
There you go. All right. So, what's the value of using protective orders when intervening in court proceedings?
Is it to stop the actions of the person causing injury?
Yes, it is to lawfully stop enforcement until instruments are produced and examined. Remember, if we want motion of productions of the original notes and things of that nature, we also want to examine them. We want to be able to fully examine them yourself and make copies of them yourself. You do not want them to give you a copy of anything, because how do you know what they're handing you as a copy was a copy from the original? And it cannot be proven unless the original is present and you're able to literally specifically make copies from the original yourself. Because the truth is, we can ask the clerk of court, we can bring the clerk of court as a subpoena, right, and do a deposition as well. Because the situation is the clerk of court has to have knowledge if they receive the actual original and made copies from it. Yeah. See how that motion of discovery works?
Wow.
Boy, I tell you, boy, we kicking ass today. We definitely are. But you guys need to realize that, right? Absolutely need to realize that. All right. Last question, guys. Last question. The last question is, where is your favorite place to be on Mondays at 11 a.m. Central Time and Wednesdays at 6 p.m. Central Time?
Work
Here.
here.
Work
session.
Work session 7.
Work sessions, man. Work sessions. So this is what I'm going to do for you guys. For y'all participation, I appreciate it. For the rest of the week, we're going to have a half off sale on for you guys as well. So appreciate you guys' participation and answering the questions and just seeing where you at and where you have been throughout this whole entire proceeding in season 7, and just seeing, you know, where you're at right now and where you might need to learn a little bit more and things of that nature. I could definitely come up with a whole bunch more different questions, but I think those was pretty good and still on a, you know, beginner-based level to a advanced level at the same time. So it's been great doing this with you guys today. I hope you guys enjoyed this as well. I kind of wanted to do a little something different. Did you guys enjoy?
Yes.
Absolutely.
Yes.
Absolutely. Then
We did. Thank you.
I was
Yeah, that
nervous.
was
though.
amazing, man. Thank you.
I'm glad and honored that you guys did like this. Well, don't forget though, this Saturday we do have the Bill of Rights class. I can't express this class more than anything. I mean, I know a lot of people's going to take the paid in full class. I know you want to get your car title and all of that. That's great. But know your rights. If you want in on the class, send an email to us at admin@ingodwetrustacademy.org. Again, admin@ingodwetrustacademy.org. Okay, and just say you want to join work sections, and we'll get you in here as well with us. All right. But again, the Bill of Rights class is so important, guys, again, because it's just knowing your rights and your interests in these particular things when it comes to the state, the United States, and just, you know, all of these different things. And it's important that we know how to go and seek remedy and get remedy. You know, you shouldn't have to suffer any harm or damages and not be able to do anything about it because, you know, you can't, what's the word I'm looking for? You can't seek out a lawyer or something of that nature. Ignorance of the law is inexcusable. And as I say, if we are the people and we say people are sovereign, the sovereign people established the Constitution, the sovereign people passed on certain rights for Congress to be able to do legislation, then if that's the case, then the people should know their own law. And if they don't, then that's a serious problem, because that means we are the one lacking. The reason why the country is in the situation that it is today, or the people itself, is because the ignorance of the people when it comes to the law. We have to change that narrative. In order for us to do that, this has to be a repetitious thing for us. Time plus consistency equals growth. I don't care whatever you do and put that into. Those things are going to happen. And I appreciate the gifts, guys. Thank you very much. But we have to literally make sure that we apply ourselves. All right. You know what I'm saying? So we just have to make sure. So let's make sure that we hop in and make sure that everything goes the way we supposed to do by us participating and learning and applying ourselves. All right. And again, yes, October the 25th, paid in full. Going to teach you how I took a $25 money order and literally received the title for my car. Paid off the whole entire note by using Accord and Satisfaction and other legal doctrines as well. All right. And if you want to know how to do that, well, welcome to class. Go to InGodWeTrustAcademy.com and you can see those things. Again, like I said, everything is going to be half off. So give us a little time. She might be already doing it now so she can hear me talking about it. But once it get put up, we'll leave it up until Sunday for you guys. All right. So I appreciate you guys, and y'all have a great and beautiful day. Thank you.
Thank you, Eric.
Appreciate you.
Gratitude indeed, family.
Gratitude to y'all, man.
Yeah,
Have a
thanks.
good rest of your day.
Make sure y'all follow, man. Like, share, and subscribe. Follow me if you're not. I'll follow back. Appreciate you.
Thank you.